Test rule, holding that the SEC acted arbitrarily and capriciously for having failed to adequately assess the economic effects of the rule. In particular, the Court stated that, quote, the Commission consistently and opportunistically framed the costs and benefits of the rule, failed adequately to quantify certain costs or to explain why those costs could not be quantified, and failed to respond to substantial problems raised by commenters, end quote. In further explaining its opinion, or its objection rather, the Court characterized the Commission's reasoning as, quote, unutterably mindless. This is particularly harsh language from any court, but even more harsh considering this is a Federal bureaucracy that they are talking about, and an important one at that. This was at least the third time in the last 2 years that the SEC rule, that an SEC rule has been struck down by the Court for inadequate cost-benefit analysis, even though the Obama administration has recognized the need for more effective analysis. In a report to Congress, the administration argued, quote, we emphasize that for the purposes of informing the public and obtaining a full accounting, it would be highly desirable to obtain better information on the benefits and costs of the rules issued by the independent regulatory agencies. The absence of such information is a continued obstacle to transparency, and it might also have adverse effects on public policy. In light of the SEC's track record, Chairman Issa and I wrote a letter to Chairman Shapiro regarding the SEC's decision not to perform cost-benefit analysis where Congress has mandated regulation. I am happy to learn that Chairman Shapiro, in response to that and other concerns, obviously, seems to have revised her earlier position on these issues. The Commission recently distributed a guidance memo to its staff that incorporates many of the policy suggestions we offered. While many questions remain about the implementation of these policies at an agency that has resisted this approach for many years, I am hopeful that the personal attention of Chairman Shapiro to the guidance's implementation will lead to an improved decision-making process at the agency. And I appreciate her thoughtful attention to the concerns that we have raised. Make no mistake, however, this subcommittee intends to vigorously monitor the implementation of this document at the Commission, and we will hold Chairman Shapiro accountable for the commitments that she has made. And we certainly appreciate your service to our government, Chairman Shapiro. You have a long and distinguished service, and we know that with some oversight from Congress, you know that we'll have a fruitful discussion today, as we always do. And for the mission of the U.S. Securities and Exchange Commission, it is to protect investors, maintain fair, orderly, and efficient markets, and to facilitate capital formation. It is clear that performing rigorous cost-benefit analysis is necessary to help the Commission successfully live up to these goals. Thank you again, Chairman Shapiro, for being here, and for our other witnesses that will be on the second panel here this morning. And with that, I recognize the distinguished ranking member of the subcommittee, Mr. Quigley of Illinois, for 5 minutes.
Thank you, Mr. Chairman. And thank you, Mr. Chairman, for holding today's hearing on SEC's rulemaking and cost-benefit analysis. Chairman Shapiro, thanks for being here. I understand this is your 4th appearance in the 112th Congress before this committee. There's no truth to the rumor that with 6 appearances you get a set of steak knives, but we do appreciate your efforts.
We'll be willing to test that later this year if the Chairman's willing.
I'd like to acknowledge the SEC's responsiveness to the inquiries and oversight of this committee. And I want to commend you for your willingness to be so responsive to the committee's numerous and varied inquiries. Obviously, the SEC has been heavily scrutinized since it assumed numerous regulatory mandates under Dodd-Frank. Regulations are vital to protecting Americans, but we must ensure that they are carefully considered. After recent investigations by the SEC Inspector General and the U.S. Court of Appeals for D.C., the SEC created new staff guidance for cost-benefit analysis. I look forward to Chairman Shapiro's testimony regarding this new guidance. As we examine this important issue, we have to remember that this is about good government, pure and simple. As Chairman Shapiro previously noted in a January 26 letter to Chairman Issa, quote, the primary purpose for performing cost-benefit analysis should be assisting the Commission in making sound regulatory choices about the difficult discretionary decisions with which it is faced. Since Dodd-Frank was signed into law, the SEC's cost-benefit analysis procedures have been heavily criticized. According to a March 6, 2012 Bloomberg article, the SEC's Dodd-Frank-related rulemaking has slowed in the face of these criticisms. While we have to hold the SEC to the highest standards, the regulations that have been delayed are critical to addressing the causes of the 2008 financial crisis. There can be no amnesia about the fact that financial markets were not working for Americans before the financial crisis. A hands-off approach by Federal regulators contributed to the fraud that destroyed the retirement income of thousands of Americans. Quote, "If our economic system is going to work," says Nobel laureate Joseph Stiglitz, "then we have to make sure that what people gain when they cheat is offset by a system of penalties." The financial regulatory reform law passed last year was a step in the right direction, but it alone is insufficient. Trust in our financial system is at its lowest ebb, which means that laws have to be enforced, and the SEC needs to be a strong enforcer. Unfortunately, the FY 2012 budget only appropriated $1.3 billion to fund the SEC. For comparison's sake, Citibank spent $1.6 billion on marketing alone in 2010. How is the SEC expected to police Wall Street when its entire budget is less than the marketing budget of one bank? I strongly support cost-benefit analysis for SEC rulemaking, but challenges to the SEC's cost-benefit analysis process should not be used by those opposed to financial reform to delay or derail the Commission's implementation of Dodd-Frank. Our country will be safer from another financial crisis if the SEC implements Dodd-Frank in accordance with the law and in a timely fashion. I look forward to the testimony of all of our witnesses. And without objection, respectfully, Mr. Chairman, I ask that a letter addressed to the Chairman, yourself, and myself from the former Chairman Harvey Pitt be included in the record.
Without objection. Well, with that, we'll ask our witness to stand and be sworn in, as is the practice of this committee. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right. You may be seated. Let the record reflect that the witness answered in the affirmative. Chairman Spiro, I know you've testified a time or two before Congress, so we don't have to explain the lighting system. For those watching, we have a very simple thing everybody knows from their stoplights. Green means go, red means stop, yellow means, well, hurry up. So with that, if you can summarize your statement, and please feel free to take as much time as you need to fully summarize that. With that, you're recognized.
Thank you, Mr. Chairman. I would note that I think this is my 42nd testimony since I became Chairman of the Securities and Exchange Commission. Chairman McHenry, Ranking Member Quigley, members of the subcommittee, I do appreciate the opportunity today to address the apparent confusion regarding whether there is an aversion to providing economic analysis in Commission rulemakings. The SEC has for years considered economic analysis to be a critical element of its rule-writing process. Indeed, I believe the SEC's substantive rule releases include more extensive economic analysis than those of any other financial regulator. Economic analysis is a challenging task. Predicting how people and entities will respond to regulatory changes involves extremely difficult judgments. While supporting rulemaking with economic analysis is difficult under the best of circumstances, the unprecedented number, scope, significance, and complexity of rulemakings required by the Dodd-Frank Act have stretched the analytic and resource capabilities of the agency. With passage of the Dodd-Frank Act, the SEC, which might normally write on average about 20 rules in a given year, received a mandate from Congress to promulgate almost 100 under impossibly short time frames. As always, our goal in addressing these statutory rulemakings has been to get them right, but also to get them done as quickly as possible to provide certainty to our markets and to our regulated entities. Our rulemaking process has been open and transparent, seeking detailed input from interested parties through meetings and comments, in many cases even before proposing rules. and our formal rule proposals include economic analysis and seek comment and data from the public and industry to inform our thinking about the potential economic impacts of the proposal as the rulemaking progresses. And finally, when rules are adopted, after careful consideration of the comments and any additional data provided by commenters, we again include an economic analysis. The economic analyses we have done have informed and improved our rulemaking. The Commission and its staff, including our economists, have spent considerable time grappling with difficult judgment calls in the scores of rules that the Act requires the Commission to issue. As you know, the SEC's cost-benefit analysis and rulemaking has been subject to reviews by the GAO and the SEC's Inspector General. While these reviews found that the Commission engages in a systematic approach to cost-benefit analysis and rulemaking, they also provided useful direction for improvement in our processes. A recent court decision and communications from members of Congress also have raised issues about certain aspects of the Commission's economic analysis and rulemaking. We have learned valuable lessons from our experiences in implementing the Act to date. As a result, our rulemaking processes have continued to improve and evolve. As part of this continuing effort, I directed the Division of Risk, Strategy, and Financial Innovation and the Office of the General Counsel to develop specific guidance for staff engaged in rule writing to further improve the economic analysis the SEC employs. Recently, they provided the SEC's divisions and offices with detailed guidance on conducting economic analysis and rulemaking. The newly operative guidance also has been provided to my fellow commissioners to solicit their views and to incorporate their suggestions for any additional process improvements. Among the specific steps that we have been taking and that are included in the current staff guidance are involving our economists in the rulemaking process before preferred approaches are decided, assuring that rule releases clearly identify the justification for the proposed rule, such as a market failure or a statutory mandate, where a statute directs rulemaking, considering the overall economic impacts of the rule, including those attributable to congressional mandates and those resulting from the Commission's exercise of discretion, quantifying the costs and benefits where feasible and where not feasible, transparently explaining why not, more fully integrating analysis of economic issues in the Commission's rule releases, explicitly encouraging commenters to provide quantitative, verifiable estimates of costs and benefits, and adding greater discussion of reasonable alternatives not chosen. In conclusion, economic analysis is a critical element of SEC rulemaking. As we've worked through the unprecedented workload required by the Dodd-Frank Act, we've learned a great deal, and our rulemaking processes have continued to evolve and improve. Our new guidance reflects many of the current best practices in economic analysis, which the agency will continue to refine in the future as necessary. And I am, of course, happy to answer any questions.
Thank you, Chairman Shapiro. And thank you for your service to our government. You have a long and distinguished career in government service and broadly in the financial marketplace. And I want to start, before anything we say today, and thank you for your service. We also know it's difficult to testify before Congress, but you've been willing to submit yourself to this process. We certainly appreciate it. And as I said in my opening, and as well as with the mission statement of the subcommittee and this committee, it's important that the American people know what's happening in their government so they have some confidence in it. So with that, I recognize myself for 5 minutes for purposes of questions. I want to begin by the culture within the SEC. Now, the SEC has very fine staff. You have over 3,000 staffers. But Meredith Cross, who is the Director of Corporate Finance, she's testified before this subcommittee and before Congress. She's a very fine individual. But culturally, the SEC, if we look at an email from September of 13th, 2010, quote, from Meredith Cross, the Director of Corporate Finance, to the Director of RiskFin, right, which is this process where you're going to have economic analysis attached to it, cost-benefit analysis. Quote, I think there will be some rulemaking that it doesn't bother anyone to say the rule benefits along the lines of what Congress was trying to achieve. But there will be some where we really can't go there and maintain any level of internal harmony, end quote. Next quote, my main request is that RiskFin not add qualitative cost-benefit discussions that could be controversial without having senior discussions. It seems to me that there is a deeply held cultural problem with cost-benefit analysis if you have to have senior-level discussions before an economist attaches any real cost that could raise problems. And so the reason why we have a commission is not to put power in one person, but to hash out this controversy and try to get better rulemaking more agreeable to everyone. I want to go on to something else. In your prepared testimony today, you said, quote, no statute, and we'll bring this up on the screen, no statute explicitly requires the Commission to conduct a formal cost-benefit analysis as part of its rulemaking activities, end quote. Well, let's go back to the House Commerce Committee report that accompanied H.R. 3005, the National Securities Market Improvements Act. Quote, in considering efficiency, competition, and capital formation, the Commission shall analyze the potential costs and benefits of any rulemaking initiative. The Committee expects that the Commission will engage in rigorous analysis pursuant to this section. Such analysis will be necessary to the Congress in connection with Congress's view of major rules. So what's important about this, and this is back from 1996 when that became the law of the land, and there's a speech that we can go on to about Chairman Bliley when this passed. The point is, and my question is cost-benefit analysis the rule of the land, the law of the land, for the Securities and Exchange Commission?
Mr. Chairman, it absolutely is and has been for many years. While the testimony says there's no specific statutory requirement to conduct cost-benefit analysis, there is, and we certainly acknowledge in our testimony and in our actions, that there are requirements for the Commission to conduct a Regulatory Flexibility Act analysis, a Paperwork Reduction Act analysis, and whenever we are engaged in rulemaking, to consider, in addition to the protection of investors, whether the action will promote efficiency, competition, and capital formation. And when we're doing rulemaking under the 34 Act, to consider burdens on competition that our rules might impose. So we do broadly economic impact analysis, which often includes a cost-benefit analysis. And of course, under the new guidance, it's quite explicit the extent to which the staff needs to try to quantify costs and benefits, and where they can't, explain why. But if I could just add one other thing, I think Meredith Cross is one of the finest public servants I have ever worked with. She's only been at the SEC a couple of years and came from the private sector. She believes deeply in cost-benefit analysis, economic analysis, and our engaging in rulemaking in a way that is fully transparent and responsive to congressional mandates.
Well, I think it's important to understand the cultural problem here that I see with the communications within your staff and the discussions going forward. So the question is about this guidance that you're working through that mandates cost-benefit analysis. And the question I have is, does it mandate that before these rules can go forward, there has to be basically clearance through the economist on the cost and benefits of rulemaking?
Yes, the new guidance. I'm sorry, that is on. The new guidance does require that even before there's a preferred approach from the rule writing divisions about what a regulatory response might be, that the economists need to be involved. They are to be integrated into the process as key policy choices are made through the pre-proposal stage, the proposing stage, the comment period, and the adopting stage. And they are as integral a part of the rulemaking team as anybody else.
But is there veto power?
I believe there is sign-off, I have to pull the guidance out to look at it specifically, by the economists on the economic analysis.
Please go ahead, because I'd like to know. I think it's important for folks to understand. Is it required as a precondition?
Concurrence is required by the economists, yes.
Concurrence is required?
Yes.
So that could act as a veto power?
It certainly would be something that would be brought to the attention of the commissioners if there was no concurrence. And it's important to note that the commissioners are deeply involved in any rule proposal and any rule adoption, including and analyzing whether the staff's cost-benefit analysis is up to the task, meets the requirements that they think are important, whether we've explored the appropriate issues.
So roughly how many economists do you have at the Securities and Exchange Commission?
We have, working on rulemaking, we have 24 economists in risk fin. We have a number of additional economists who are doing risk analytics, modeling.
And what is the comparable number of attorneys you have?
We have obviously many more attorneys. I'd be happy to get you the exact numbers.
Is it hundreds?
Oh, yes, it's
hundreds.
Hundreds of attorneys. We've also are in the process of hiring 20 additional economists this year, and we've asked in the FY13 budget for 20 more economists. So,
and is that part of risk fin?
Those are all part of risk fin. There actually are economists in other parts of the agency, but in terms of those who support from an independent perch the rulemaking process, those are in risk fin.
Thank you. And with that, I recognize the ranking member for his 5 minutes, but I ask unanimous consent that you have 2 additional as well, without objection.
Thank you, Mr. Chairman. Madam Chairman, my harshness isn't directed toward you, but when we start thinking about benefits, you have to think about what the costs are of the risk. So in a broad picture, those were some pretty big oops since the 2000s. We missed Enron, we missed WorldCom, Madoff's Ponzi scheme. Extraordinary cost and risk. So how do you determine, when you try to do this, cost-benefit analysis? How can you possibly take into consideration the thousands of lives that were ruined and the millions of dollars that were lost with lack of accurate and adequate regulation?
Congressman, even the GAO has recognized that the task of quantifying costs is difficult, but the task of quantifying benefits is very much more difficult because they are often very, very hard to put a dollar number on, to monetize. And so our challenge is to do the best that we can. Where we can't actually quantify the benefits with hard numbers to explain what we believe the benefits are from a qualitative perspective, and lay that out for commenters and the public to react to.
But what do you use now to try to ascertain that the potential risk involved? I mean, they have to be included in your analysis, correct?
Right, and we do talk about depending upon the rulemaking, what, for example, with respect to over-the-counter derivatives and that were largely unregulated or wholly unregulated during the financial crisis and leading up to that time period. We talk about the impact of the financial crisis on the economy and on citizens, and talk about the benefits that we think creating a regulatory regime around derivatives will be. But again, they're very, very hard to quantify.
Well, but let's just elaborate to an extent. I mean, just dealing with cost, do you talk with industry experts about their best guess on what cost would be when they talk about regulating a product?
We do. We talk to them about direct costs that they might incur as a result of a new rule. Do they have to put in a new compliance system? Is there new record-keeping obligations? Staffing. We talk about competitive effects on them, and what might they withdraw from a business, and what would be the impact not just on them but on the economy or their customers more broadly. So we talk extensively with them. We also, after we've made an estimate of what we think the costs are and detailed what types of costs we believe there to be, we affirmatively ask for data that can help support the cost-benefit analysis that we've done, or that tells us we got it completely wrong and we need to go back to the drawing board. So we affirmatively seek that data from commenters. Oftentimes, only industry has access to the data that might be useful for us to understand what the true costs are of a regulatory action.
In cost and benefits, I mean, I guess you come to the conclusion you're not going to be able to capture it all, correct?
It's very difficult. If I could give you another example, when we do a disclosure rule, there are lots of benefits to that, including that investors will have better information upon which to make their capital allocation decisions. Maybe that will lower risk premiums. It will lead to lower prices and better competition. Those are all things that we try to measure as benefits. Might it lead to some fewer number of securities class actions with hundreds of millions of dollars of awards? Those kinds of things are benefits that we try to measure, for example, when we do a disclosure rule. The costs are going to be the costs of providing that information to investors, the costs of assembling disclosure documents for the intermediaries that are required to provide them.
And on the benefits side, you talked about getting industry help on the cost side. Besides the things you just mentioned, who, if anyone, helps detail, what the risks are in helping you ascertain how risky a product might be, and what the benefits of reducing that risk are?
Well, in that regard, the staff of the SEC has a lot of the expertise to understand the risk profile, for example, of a product, or to study it and learn it. Industry is much better situated to provide data and to influence the rulemaking process in a very specific and operational kind of way. We do have investor groups that often comment very constructively and helpfully, and we rely on their input and data as well. They are sometimes in a position even to commission studies and analysis that are then provided to us and part of the comment file.
And if you have answered this, I apologize, but in short, do you always use cost-benefit analysis as you're developing new rules for consideration?
We always do regulatory flexibility analysis, Paperwork Reduction Act analysis, and analysis of the impact of our rules on competition, capital formation, and efficiency. We don't always find ourselves in a position to be able to monetize those costs and benefits, but we always have at least a qualitative discussion.
I began the conversation talking about the disparity in budgets. Do you feel like you have a sufficient budget to police Wall Street?
We are. I've become fond of saying we're about the size of the District of Columbia Police Department, yet our responsibility is to police the entire U.S. capital markets, mutual funds, public company disclosure, brokerage firms and investment advisors, and now hedge funds and over-the-counter derivatives, as well as our many stock markets and trading venues. So while Congress has given the SEC some budget increases in the last 2 years, for which we are very grateful, my view is that the agency is still under-resourced to the task that we face.
Thank you, and I yield back.
But hopefully you have fewer cars stolen than in the District of Columbia. With that, I recognize the Vice Chairman, Mr. Ginta, for 5 minutes.
Thank you, Mr. Chairman. Thank you very much for appearing this morning. Can you just briefly talk about, I listened to your opening statement, I just briefly read through it again. It seems like, I don't want to put words in your mouth, but the Dodd-Frank Act has dramatically expanded the SEC role and the requirements placed on the SEC. Is that a fair statement?
In the rule rounding context, yes.
And I think you refer to some of those requirements in Dodd-Frank as either overburdensome, challenging.
I don't believe I said overburdensome. I think some of them are challenging. Some are very, very different rulemakings for the Securities and Exchange Commission. For example, the requirement to have disclosure rules around the use of conflict minerals mined in the Democratic Republic of the Congo. And those are very different kinds of rules that we've been called upon to do. The over-the-counter derivatives market, wholly unregulated market until Dodd-Frank. We've developed a lot of expertise. We continue to develop it, but again, challenging because of both its breadth and its complexity and its novelty from our perspective.
So is Dodd-Frank putting, I guess I'll ask it, is it putting an undue burden on the SEC?
I think I'm enormously proud of the work the SEC staff has done to date. We have about 100 rulemakings to do and 20 studies. I believe 13 or 14 of the studies are completed. 75% of the rulemakings have been either proposed or adopted. But this is with staff pretty much working around the clock for the last year and a half. But we continue to work. It is, as I said to the Chairman earlier in a private conversation, this is the law of the land, and we will implement it to the best of our ability. And the staff continues to work towards doing that.
Well, how would you feel if we repealed it?
I think my personal view is it would be a mistake to repeal Dodd-Frank. I think we are working through in the rulemaking process those areas where the legislation has created challenges to implementation. But I think there are significantly important portions of the law that deal with systemic risk and regulation of entirely unregulated areas that are important. We think that to the extent there are imperfections, that we can deal with them largely through the rulemaking process.
And going back to the rulemaking process, is 20 additional economists enough, in your opinion, to implement?
I think, first of all, I should say that we're getting people of an enormous quality and depth of expertise, and even the Inspector General's report and the GAO report, but particularly the Inspector General report, acknowledge deep knowledge and expertise on the part of our SEC economists, and our chief economist is here with me today. We can certainly use more economists, but I think this is a very, very rapid expansion of our economics group over just a very short period of time.
But I'm not sure, in your opinion, though, would the 20 additional be sufficient? You said it's a rapid expansion, but it's 20, correct?
It's 20. We have 24 currently working just on rulemaking. We have other economists doing other kinds of work like litigation support and risk analysis and quantitative modeling. 20 we expect to hire this year, of which 17 are PhDs, and as soon as the academic year is over, they will be joining us. And then we've asked for 20 additional in our FY13 budget. I think it is our view that that will help us significantly. But I would also add that as a result of Dodd-Frank, extraordinary amounts of new data will be coming into the agency about hedge funds and their investing, over-the-counter derivatives, and in a number of other areas. And so we will need economists who have analytic capabilities to help us understand what that data is telling us, and also to do our 10-year review of the Sarbanes-Oxley rules that's required under the Regulatory Flexibility Act, which we will begin in 2013. We will need economists to do those reviews.
Well, if the assumption is that we need additional economists, and you have a budget request in your an increase in your budget request, to help you with that, would you consider freezing certain hiring areas, particularly attorneys, in order to fulfill the need on the economic side?
Congressman, I don't think it's as simple as saying freezing attorneys and hiring economists. We have very broad responsibilities, and we are also a law enforcement agency, and we cannot bring our cases and do our investigations without our investigative staff and our attorneys. We rely heavily on accountants as well at the SEC because of our responsibility for oversight of financial accounting standards. So I think we have shifted resources around the agency as appropriate to support those divisions that are struggling, in particular with the Dodd-Frank rulemaking. And I think the risk fin division, where the economists are housed, has particularly been a beneficiary of that flexible approach to staffing.
Okay. Thank you. I yield back.
I recognize gentlelady from New York, Ms. Maloney, for 5 minutes. Co-author of our crowdfunding legislation that is included in the Jobs Act.
Thank you, Mr. Chairman, and thank you for mentioning that. I enjoyed working with you, and welcome, Chairwoman Shapiro. I believe this is the 4th time that you have testified before the Oversight Committee or one of its subcommittees, but in your opening statement, I believe you said you have testified 34 times before Congress. Is that correct?
42.
42 times before Congress. How in the world do you have time to do your rulemaking when you are before Congress so many times?
Well, I view this as a very important part of my job, and clearly a very important part of Congress's job to oversee the agency and our activities. So,
42 times. That's got to be a record.
I work on the weekends.
Okay. The SEC's mission is to protect investors and to maintain orderly markets and facilitate capital formation. And while some concerns have been raised in the past about the SEC's economic analysis, this hearing's title suggests that the SEC has systematically avoided cost-benefit analysis whenever it is possible. So I would just like to ask you, Chairwoman, under your leadership, how many SEC regulations have been overturned due to the quality of the economic analysis?
In my little over 3 years at the SEC, we've done 51 final substantive rules, and one has been challenged and overturned.
Well, I think that that's a pretty good record. And despite the majority's title for this hearing, I do not see any evidence of any aversion to cost-benefit analysis or engaging in analysis to understand the impact of the SEC's rulemaking. And we have to realize that the SEC's rulemaking is being put in place to protect this country and our citizens from the $18 trillion economic loss caused by the financial crisis. Economists, government leaders have all said this was the first recession that was caused by the financial mismanagement of markets. Now, I would like unanimous consent to put in the record an article dated March 6, 2012 from Bloomberg. And that article, is that all right to put in the record?
Can you give us further reference what that is?
I'll give you a copy of it. I'll put it in your hands. If you don't want to put it in the record, you can turn it down. Anyway, I think
the title of it?
The title was an article about the ruling in the Business Roundtable and the SEC. And it talked about...
If it pertains to today's hearing without objection, we'll allow it to be part of
the
record.
Whatever. It's an interesting article. Anyway, the article says that it has slowed the Dodd-Frank rulemaking process, which I think is really important. If it slowed the Dodd-Frank rulemaking process, that means you're slowing the protection of the American economy and our citizens from another financial crisis. Now, this article says, and I quote, and it talks about the delayed regulations. And he says that these regulations are designed to curb the kind of risky practices that fueled the 2008 financial crisis. Some of the SEC's delayed rules strike at the very roots of the causes of the 2008 crisis. One example is a rule that would ban firms from designing asset-backed security deals that put their interests in conflict with investors. Other rules are being drafted and revised in coordination with other regulators, complicating the process. These include the Volcker rule to ban proprietary trading at banks, the risk retention rule, forcing lenders to keep a stake in loans they bundle, and several rules defining new swap market oversight. Now, the risk retention rule, many believe that would have prevented the subprime crisis. So I am concerned that these rules are not in place. And Chairwoman Shapiro, is this a good summation of some of the rules you're working on, rules designed to prevent a repeat of the practices that led to the financial crisis?
I think so.
How are these rules? You should prioritize your rules. You should prioritize that you're taking care of the rules that caused the crisis first. You've got a lot of responsibility. We know your budget's been cut. But the rules that I just mentioned, when are you going to get them completed?
We have tried to prioritize the rules. The ones that we have done first were those that had the shortest statutory deadlines, although admittedly we have missed a number of statutory deadlines. And we're proceeding to work as quickly and as deliberately as we can. As I said at the outset, our goal has always been to get the rules right, to do adequate analysis of the economic impact and also the usefulness and workability of the rules.
Do you think you will complete these? When do you think? Do you think you'll complete them this year?
I think we will complete the bulk of the rules this year, particularly in Title VII, which covers over-the-counter derivatives. And, of course, we have finished a number of rules. The whistleblower rules were done. The registration of private funds are done.
But the ones that I mentioned that Bloomberg News pointed out were the crux of what caused the financial crisis, those I would venture to say are the most important.
I don't disagree with you.
I request an additional minute, if I could, from the Chairman.
In addition to the minute you've just taken, or
yeah.
One additional minute?
Yeah.
Oh, without objection, the gentlelady will have one additional minute.
I just want to go back to the hearings that we had back in 2008 when President Bush asked for an astonishing $700 billion to prevent a contagion spreading through the financial markets, and this Congress approved it. And it saved our financial markets. And on that day, members of this committee had a very important hearing with the former chairman of the Federal Reserve. And it was a shocking hearing. I'll never forget what he said. He said, "I made a mistake," and I'm quoting, "I made a mistake in presuming that the self-interest of organizations, specifically banks and others, was such that if they were best capable of protecting their own shareholders." This was the strongest statement I have ever heard from the former chairman of the Federal Reserve, that we need to have strong regulations to prevent it. After the Great Depression, we put some rules in shape. We had 60 years of economic prosperity. Please complete your rulemaking. Congratulations on your hard work.
Gentleman from South Carolina is recognized for 5 minutes.
Thank you, Mr. Chairman. I was going to use my time to ask about the holding in Business Roundtable versus SEC because the holding, Mr. Chairman, is very provocative. I do want to commend Chairwoman Shapiro for not criticizing an unelected group for passing judgment on that law, as has been done recently. But what I'm going to do instead, Mr. Chairman, because you inspired me with your line of questioning, is I'm going to give you my time, and perhaps I can ask another panel to work our way through the holding in Business Roundtable.
Thank you. I certainly appreciate the gentleman yielding. And to my colleague's question earlier about the prioritization of Dodd-Frank rulemaking, just for the record, the SEC is attempting to have rulemaking on conflict minerals in the Congo. So, in terms of prioritization, I think it would be best for the SEC to attempt to do that. The question about the cost-benefit analysis. Now, understanding what obviously two sides of the aisle. One says that there are costs and wants to focus on the cost of government regulations. The other wants to talk about the benefits of government regulation. Perhaps we should have some harmony and agree that there are both costs and benefits to regulations. Now, I'm not going to ask the question. It is an economic reality and an economic fact that regulation, no matter how beneficial, no matter how benevolent, has costs associated with it. There also, some regulations have benefits that outweigh those costs, and we all have that debate in society on where that line is, and there's reams of economic analysis about how to balance those cases. The question before us is about the guidance memo with the SEC, and I'm very grateful, Chairman Shapiro, for your leadership on this. The question is this guidance memo on cost-benefit analysis now binding?
Yes, Mr. Chairman, it is. Although I will say that I have asked my colleagues on the Commission for their comments and input, so it's possible that the memo and the guidance will evolve with their comments. But yes, it is binding.
Will that process be public once this memo is fully decided with all input from commissioners?
I'm sure that there will be opportunities for us to make it public, yes.
Okay. And have you directed all the offices and divisions within the SEC to adhere to this guidance?
I haven't sent out a specific directive, but everybody understands that this, and it has been distributed to the rule writing divisions. They all understand that this is how rule writing economic impact analyses will be conducted, yes.
Okay. Has that writing been done has it been done in writing?
Well, it was directed to each of the divisions.
Okay. So there's no doubt from all the staff that's working on it that it is binding.
I have no doubt at all. And, of course, the Commission is the ultimate arbiter of all of our rule proposals. So I would expect that if an analysis did not live up to the expectations of the guidance, the Commission would make that clear to the staff.
Okay. Now, would you agree, and this is just a basic question, that economists should be doing the economic analysis?
I think the economists should be deeply involved in the economic analysis. I think it should
Who should be doing economic analysis if not economists?
They should be doing the analysis, but I think they can't do it in a vacuum without consultation and coordination with the rule writing teams as well. with analysts and others who have expertise perhaps in the particular area, the particular product.
So are there exceptions to economists doing the economic analysis?
No.
Okay. Okay. I just want to make sure. I mean, these are very basic questions. Now, I understand that the SEC is currently has 28 Dodd-Frank rules that have been proposed but are not yet final. Will this guidance apply to retroactively to those rules that have been proposed but are not yet final?
You're correct. There are 28 rules that have been proposed that have not been adopted finally. The staff is analyzing all of those cost-benefit analyses for each of those rules because, as you know, many of them actually followed much of this guidance because we had adopted in practice Circular A4 provisions, executive order provisions, and so forth. So many of them will not have issues, but the staff is going back through each of them to determine whether we need to do any more analysis in light of the new guidance. I will say, with a rule proposal that we expect to adopt tomorrow, we did just that, and we reopened the comment period, put new data and economic analysis in the public comment file as a way to inform our ultimate final rule adoption.
So this guidance will be binding on those 28 Dodd-Frank. This guidance will be
yes, going forward, yes.
Okay. And is there any process or thought of looking back at regulations that are on the books and making sure this guidance is used?
No, I don't think so. I mean, the rules are final. Industry has started to develop its systems, operations, compliance around rules that are already on the books. And as I said, because I think it's so important to understand, we have been doing economic analysis in all of our rules. We haven't, for example, always chosen, as the new guidance requires, a pre-statutory baseline, which has been an important point, but we have always done economic impact analysis. And indeed, the report that was one of the witnesses on the next panel will speak to showed that for 54 rules that were done by the SEC coming out of Dodd-Frank, we had done 347 pages worth of cost-benefit analysis. Compare that to the Federal Reserve, which did 24 rules and 12 pages of cost-benefit analysis, or the FDIC with 6 rules and 6 pages of cost-benefit analysis. So I would not want it to be lost that this agency has been engaged in significant economic analysis. This guidance gives us clarity and some more specificity, particularly around the selection of a baseline and the preference or the requirement to use a pre-statutory baseline.
Okay. Now, we have testimony in the second panel that says that 4 of those rules included no cost-benefit analysis.
Yes, but we should be clear what those were. One was a delegation of authority to the chief accountant. One was a delegation of authority to enforcement. One was a temporary exemption related to security-based swaps. And one was the Reg FD amendment, where Congress said, remove from Reg FD the exemption that exists for credit rating agencies. And so we did that quickly. We didn't see what a cost-benefit analysis would yield there, since we had no discretion whatsoever in enactment of that rule. So going back to the Becker Amendment, well, actually, why don't we wrap up this round, and we'll go to a second round because the time has expired. With that, we'll open a second round of questioning, and I recognize myself for 5 minutes. So with the Becker memo outlining cost-benefit analysis and the idea that if Congress mandates a rulemaking to the SEC, that the SEC does not have to do cost-benefit analysis. It sounds like that still is in your thinking based on the 4 that you outlined, 2 of which were mandated by Congress. No, Congressman, not at all. Of course, those were done before the new guidance. Yes. So they operated under the pre-existing guidance. And what I will say is that the Becker memo was advice from a general counsel to an agency that was facing really a daunting number of congressionally mandated rules to write. And it set forth an initial framework to analyze what needed to be done when the Commission exercised discretion. And there was concern, frankly, about not second-guessing the judgments that had been made by the Congress in the passage of the Dodd-Frank Act about what needed to be done. That said, going forward, we have clearly said in this guidance that we will evaluate the economic impacts of the pre-statutory condition, as well as those areas where we are actually exercising discretion. Those 4 that you mentioned predate this guidance.
Okay. So to be clear, the new guidance, in effect, repudiates the Becker memo that was operational before the guidance.
I think there are some things in the Becker memo that are actually captured in the new guidance. For example, to the extent we are exercising discretion, we should describe that, and we should be honest and clear with the Congress and the American people that we're doing something because we think it's the right thing to do, not because Congress directed us to do it. It calls on us to identify the choices that are being made when we have alternate ways to achieve the regulatory purpose, and to quantify wherever possible. That's incorporated in the new guidance. That said, there's much more required in the new guidance that was required in the very brief Becker memo. And of course, one of the most important changes is the requirement that we use a baseline that includes the existing state of the world, including the state of efficiency, competition, and capital formation. And it is against that baseline that we will use consistently through that rulemaking that we measure the impact of our rules and the impact of potential reasonable alternatives. Okay.
Now, the Jobs Act was enacted last week, signed into law. Has a number of provisions, but one of the provisions that I, along with my colleague, Ms. Maloney, were highly involved in is the so-called crowdfunding portion of this, which was originated out of the House and called the Entrepreneur Access to Capital Act. It received over 400 votes in the United States House of Representatives, meaning it was a very overwhelming bipartisan vote, received a bipartisan vote through both subcommittee and full committee markup. Was included as a provision of the Jobs Act. It also is commented upon from your March 13th letter to Chairman Johnson in the Senate and Ranking Member Shelby. And you outline your objections, and I assume it's just your objections to this, and a number of other provisions. So I'm very concerned about implementation. Now, I'm not going to ask you broadly because I've got a very specific interest on the portion that I authored on crowdfunding. You have 270 days to write and promulgate rules for crowdfunding. I'm very interested in the process you're taking now, the number and type of staff you'll have working on this issue, and would like to give you an opportunity to address those things.
I'm happy to, Mr. Chairman. As you know, as we've discussed, the Jobs Act is the law of the land, and the SEC will implement it and as faithfully to congressional intent as we possibly can. A number of the provisions, as you know, are immediately effective, the IPO on-ramp provisions, and those don't require SEC rulemaking. They have required that we provide some mechanisms for filing with the SEC and some clarifications around how Reg A exemption will work, and around how some of the provisions will work, and we have done that. Within a week of the bill being signed, we had set out both a system for processing confidential filings and issued 2 sets of frequently asked questions on the process. With respect to crowdfunding, there is a 270-day deadline. That is very tight, as we know from Dodd-Frank. Congo had a 270-day deadline for rulemaking. We know how difficult that is. I'd have to get back to you on specifically how many people are working on each provision, but I can tell you that because we had significant work underway already at the SEC to work on issues related to small business capital formation and general solicitation, the shareholder triggers, and crowdfunding, that work is no longer necessary, and those people can be shifted to the rule writing provisions.
Okay. And I understand from your letter your aversion to this crowdfunding piece, and I want to ensure that the SEC follows the intent of Congress.
I can just assure you again that the law of the land is the law of the land, and we will do what Congress has asked us to do, as we have always tried to do. Whether we agree at the end of the day or not, we will do our best to fulfill what you have intended for us to do.
Thank you. And with that, Mr. Quigley is recognized for 5 minutes.
Thank you, Mr. Chairman. I have no questions, Ms. Shapiro, at this time.
I recognize the Vice Chairman, Mr. Genta, for 5 minutes.
Thank you, Mr. Chairman. I want to follow up on something we were talking about before. You mentioned the rulemaking relative to minerals, conflict minerals in the Congo. If we could pull up slide 5 for a moment. And I want to read to you Section 1502 of Dodd-Frank. This is the conflict minerals rule. It says, the rule's stated objective to reduce murder and other forms of criminal violence in the Congo. When I look at this slide, and I don't know if you have it in front of you, but this is the guidance of cost-benefit analysis. Where can you tell me where in that guidance there is any kind of specificity that we could apply to the conflict minerals rule?
Excuse me. I can't read the whole thing. Let me say that the conflict mineral rules, as I said earlier, are very different rules for the Securities and Exchange Commission. We generally write rules that deal with financial transactions and disclosure requirements. This is, in essence, a disclosure rule, but it's really quite a different one. And
it's more of a social objective.
But Congress, and so what we've quoted here, I believe, and again, I'd have to go back and look at the full page. We have restated Congress's objective for us, not an objective we believe that can be achieved by the conflict minerals rule. We have tried to be very faithful, because this is outside of our wheelhouse, to what Congress has said the purpose of this provision of the law is to deal with massive human rights abuses in the Congo. And that's what we've been given, and that's what we're trying to work with.
Well, and I appreciate that. I agree with you. I don't think that your guidance, which is cost-benefit analysis, reducing incentives of misalignment, reducing monitoring, dealing with monitoring costs, lowering the cost of capital, I don't think that has anything to do with the social objective that was included in Dodd-Frank. My earlier conversation is the expansiveness of Dodd-Frank and the burden it places on the SEC. I think there are many that would like you to focus on a certain scope of issues in a reasonable way, and I think that you want to try to meet that same objective. This clearly, well, at least in my view, takes your limited focus of economics and apply it to something that is social in nature. So, I mean, I heard what you said about you'll do whatever Congress essentially says, but I guess let me ask it this way. Would you prefer that Congress not make these types of decisions and ask the SEC to then promulgate rules or address them through a cost-benefit analysis process?
I think that's a very hard question, and it really is a question for Congress.
I thought it was an easy question.
No, there are no easy questions anymore. I think it's really a decision for Congress whether the Federal securities laws are an appropriate vehicle for disclosure of this type, and there are several. I will say the vast majority of Dodd-Frank rules relate to specific financial matters that go to systemic risk, that go to investor protection, and we have a high level of comfort with our ability to master, do full analysis, and understand the comments that we receive before we adopt our final rules. This one is harder. There's no question about it. It's one reason we have missed the deadline, and we have taken so much time. We've had so many meetings. We have had roundtables. We've engaged very broadly with the corporate community as well as with the NGOs, the Jesuit Conference, and a number of others to try to understand the implications of these rules and to do the best job that we can.
All right, well, let me ask, how about this? Is it fair to say that the conflict mineral rule is more about social justice than financial analysis?
I think Congress clearly says that in the language that accompanies the debate around the rule, that it is about trying to make better a horrific situation in the Democratic Republic of the Congo.
But that's not the jurisdiction of the SEC.
No, but the disclosure documents filed by public companies is the hook here for furthering this goal.
Are there other ways in which we could meet that objective outside of the SEC?
I assume that there are.
Yeah.
I'm not an expert on those, but I assume so.
Okay. Thank you very much. I yield back.
With that, Mr. Gowdy from South Carolina.
As before, I would give the chairman of my time for him to use in such fashion as he sees fit.
All right. Thank you. I certainly appreciate that. And just to finish out my question on crowdfunding, not to belabor the point, but I will belabor the point. You know, there's obviously a comment period and things of that in the normal process of rulemaking, but I want to make sure that market participants and members of Congress that crafted the jobs bill have adequate opportunity to comment throughout this process to make sure that what the SEC enacts is actually Congress's intent. And obviously the oversight hearings are an important part of that. And so, Chairman Shapiro, you've always been willing to give us feedback and be very forthright with that, and I thank you for that. And would ask and encourage you to continue that process throughout the remainder of this year as these rules are enacted.
Of course, we'll be happy to talk with you at any time that you want. Our rules will be published for comment. There will be an economic analysis associated with them. We will seek data to support the choices that we make and the alternatives that we offer up. And this will be a fully transparent rule writing process as we always engage in.
Okay, thank you. And you know, with the crowdfunding piece, there's extraneous provisions put into that section that the Senate added, and some of these experts have commented on, and they have concerns that the amendment that the Senate added with crowdfunding with their liability provisions are extremely confusing and riddled with hypothetical questions that raise some liability concerns. Liability, some have called it a liability trap. And so with that concern, do you see it that way?
I'm not sure I know enough of the detail to answer that. It's something we will be sensitive to. We've also actually, I should say, opened up email boxes to ask for comment even before we propose any rules on some of the issues that people feel we need to address most quickly. And we have gotten actually some significant interest from people calling to find out about how they can engage and begin to engage in crowdfunding. So I think there's, whatever the hurdles that were placed into the bill in the Senate and the ultimately adopted version, I think there's real interest in people using this provision, and we will try to provide the best guidance that we can through the rules.
Thank you. How will the SEC ensure that crowdfunding serves startups and small businesses that are currently underserved? That sort of 50,000 to 500,000 equity raising section of the marketplace.
I don't have the specific answer to that, but I can tell you that if you look back over rules, a number of rules we've done in my time at the SEC, we have made use of scaled requirements so that smaller companies have a delayed compliance date in some areas. They have lesser filing requirements in other areas. And we'll continue to look at, as the executive orders suggest, we do scaled requirements for the smallest companies.
Is that really the example of the world? As you talk to your peers in other countries around the world, the scaled regulations are really the next generation of securities regulations?
Yeah, that's a very good question. I don't really know the extent to which other countries utilize that, but we have been doing it with respect to compensation disclosure. If you look at the new rules requiring private funds reporting under Form PF as systemic risk reporting, you can see that we exempted funds with assets under management of $150 million or less completely, and those up to $1 billion that are hedge funds only report annually instead of quarterly, and much less information. So we are aggressively trying to utilize that kind of a mechanism.
Okay. Now, I'm sure you've heard of this, but this morning the Investment Company Institute and U.S. Chamber filed suit against the CFTC with their Rule 4.5. And as I understand it, the mutual fund industry claims that the CFTC has imposed an additional unnecessary layer of regulation on hundreds of mutual funds that are currently under your purview at the SEC, broadly speaking. And the lawsuit says the CFTC made little attempt to establish there is any regulatory gap to be filled here, and that the CFTC failed to conduct an adequate cost-benefit analysis before adopting the amendments. I'm not sure if they timed this in conjunction with the hearing today, but the cost-benefit analysis is interesting. But to many market participants, it seems that the CFTC's amendments could have an adverse effect on an industry that is currently regulated by the Securities and Exchange Commission. And was the SEC aware of the CFTC's actions?
I believe we were aware. They're an independent agency, and except where we've been directed to write joint rules, we aren't in a position to tell them whether or not to go forward with something, although we do try to consult and coordinate to the extent we possibly can where our rules may affect the same entities. But I just don't know the details on this. I'd be happy to try to provide those to you. Obviously with the mutual funds, even with money market funds, they weren't the cause of the financial crisis and weren't really the intention of Congress to subject them to additional regulations. But in closing, I don't know if our ranking member has any additional questions. Okay. But Chairman Shapiro, you've been wonderful to submit yourself to congressional oversight. I know you've spent some time on Capitol Hill, but I would say to my colleagues on both sides of the aisle that it's important for us to have oversight, to make sure the public knows that Congress, that their servants in Washington, their elected officials in Washington, are having proper oversight of the bureaucracy. Now, this has been a problem in all administrations. If you have Republicans in Congress, they say Democrats are subjecting that Republican president to too much oversight and vice versa. But with that, with the regulations, with the Jobs Act, the regs that the SEC has to promulgate, will you be willing to come back before the end of the summer, before the subcommittee, and give us an update on those implementations? Thank you. Thank you. And I certainly appreciate that. If we could have a regular update from your staff and from you, that would be very helpful as well. So I certainly appreciate your testimony. And with that, the committee stands in recess until we put in place the second panel.
Committee will come back to order and have witnesses take their seats. Is Mr. Verrett present today? All right, the chair will now recognize the second panel of witnesses. And I will begin by recognizing Dr. Henry Manny as the Dean Emeritus of George Mason University School of Law. Ms. Jacqueline McCabe is the Executive Director for Research of the Committee on Capital Markets Regulation. Mr. Mercer Bullard is an Associate Professor of Law at the University of Mississippi School of Law. Mr. J.W. Verrett is an Assistant Professor of Law at George Mason University School of Law. Mr. H. David Kotz is the former Inspector General of the Securities and Exchange Commission and current Managing Director of Griffon Strategies. Am I pronouncing that? Oh, Lord. Griffin Strategies. I'm sorry. It's already been a long day for this member of Congress. So with that, it's a policy of this committee that witnesses will be sworn in before they testify. If you'll please rise and raise your right hands. Do you solemnly swear to affirm? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right. You may be seated. Let the record reflect that the witnesses answered in the affirmative. Members will have 5 legislative days to submit written opening statements, and in order to allow time for discussion, I ask the panel to limit their testimony or to summarize their testimony. And if you can keep that to 5 minutes, the lights are there for your instruction. And if you could please adhere to that, we'll get time for an exchange of ideas and a discussion afterwards. With that, we'll first recognize Dr. Manny.
Thank you, Mr. Chairman.
And if you'll pull the microphone close to your mouth, they're very directionally oriented.
I presume first recognition of me is in recognition of age, but I almost believe that I would never live long enough to see the day of March 16th when the SEC put down this new memorandum. I have spent my entire career of over 50 years in law teaching pressing the idea of the need for economic analysis in legal policy making. We've had some enormous successes. I don't think there's any law school in the country today that doesn't have substantial work in law and economics. And indeed, I think the rising popularity of this interdisciplinary field in part accounts for what's happened in the SEC now. Nonetheless, most of my career was not happy in this regard. In 1966, I wrote the first book that was fundamentally critical of the SEC from the point of view of not using economics. It was a detailed economic analysis of what came to be called insider trading. It was studiously ignored by the SEC. In fact, I'm told that by decision in a staff meeting, no one would be allowed to review it. And furthermore, that I had the happy position for many years that no staff member at the SEC was even allowed to cite any work that I had written. The following year, I edited a conference that I ran that was the first comprehensive treatment by economists of securities regulation. There have been one or two spotty articles up to that point, but that was the first one. Again, it met with, I would say, resounding hostility from the SEC, as most everything that I did in those days was. So you can see that having come a long way, I don't suggest that I think that cost-benefit analysis is the be-all and end-all of correction of problems with securities regulation, but it is very definitely a step in the right direction. Having said that, I want to say some general things about cost-benefit analysis, and this in particular. First of all, that cost-benefit analysis is merely one part of economic analysis. There are occasions, as was pointed out in that memorandum, when cost-benefit analysis is not the most appropriate thing to use. Economic analysis of a non-empirical sort can be used, and each has its appropriate role. There are several aspects about overlapping on those, because I see I run out of time much faster than I ever expect to, that really I raised by way of warning to the agency. I take them in perfect good faith that they really mean what they said, but I'm not sure they know fully what the implications are of what they said. First of all, data of the kind that used in many cost-benefit analysis is about as malleable as clay. There's an old saying, if you squeeze the data hard enough, you can make it say anything you want. Well, what that does is puts a degree of responsibility for objectivity on an agency using cost-benefit analysis that maybe they're not even aware of. One of you congressmen mentioned earlier the whole culture of the Securities and Exchange Commission has not been the culture of a highly intellectualized economics department in a university. It's been heavily politicized and indeed hostile to economic analysis, because that's a kind of often serves to restrict what would be preferred political things to do. This came out in, I saw, mainly in the memorandum in two places, both footnote 16 and footnote 19, which were the principal places in which the memorandum actually mentions some of the substantive techniques and problems of cost-benefit analysis. I would like really just, I'll mention one of them as an example that this entire list is big enough to run a truck through doing away with sufficient appropriate analysis. One is the notion of asymmetric information. This is defined in that memo as a market failure. Well, if asymmetric information is a market failure, then everything in the world is a market failure. Asymmetric information merely means that two people negotiating don't have exactly the same information, the same education, the same attitudes, the same risk aversion, many differences. And to talk about it as a risk, a market failure is to, in effect, beg the question entirely even before you get started. There are several other places in that memo that if you want to talk about later, we can, which I haven't gone into. If I may take just a minute, I have a list of... If
you're able to summarize, we have a large panel. If you're able to summarize in another 30 seconds, that would be very helpful.
I would just mention and list some practical consequences that I think should grow out of this. One, I think the SEC is totally fooling itself when it talks about 17 or 20 new economists. For the job that they have really presented themselves to do well and to do adequately, I think is a minimum of 150 economists. I don't think the small numbers even begin to grab at it. And if you should pursue the number of lawyers they have, because it's long been a lawyers' agency with no input from the economists, and that ought to change. The culture and the internal dynamics of that agency should be changed because it is an economic regulatory agency. And it's not true, as I'm afraid Mrs. Maloney said, that the important thing is to get those regulations out. No, the important thing is to get regulations right. Better to get 2 correct, really effective regulations under Dodd-Frank than to get 150 out that are random, that you don't know what the impact is or what the cost-benefit is or anything else.
Dr. Manny, we'll have to leave it there, and I could listen to you all day. You're speaking my language, but I'm trying to understand the depth of your language. I think is probably a better way to say it. But with that, we'll have to recognize Ms. McCabe for the purposes of her opening statement.
Thank you, Chairman McHenry, Ranking Member Quigley, and members of the subcommittee for permitting me to testify before you today on cost-benefit analysis conducted by the SEC. I'm speaking today on behalf of the Committee on Capital Markets Regulation, of which I'm the Executive Director for Research. The committee has, since 2006, strongly supported improved cost-benefit analysis by both the SEC and other agencies. Today, the need for improved cost-benefit analysis is particularly evident in the agency's respective rulemakings under Dodd-Frank. We are deeply concerned that the inadequate cost-benefit analysis could expose these rules to judicial challenge, particularly in light of the Business Roundtable decision and a current lawsuit seeking to strike down the CFTC's recently promulgated position limits rule. The committee studied cost-benefit analysis provisions in 192 proposed and final rules issued by 15 regulators under Dodd-Frank. Here are the numbers. Our analysis found that of these 192 rules, the vast majority do not discuss the expected broader economic impact of the rule. 57 of the rules contain no cost-benefit analysis. 85 of the rules contain entirely non-quantitative cost-benefit analysis. 50 of the rules contain quantitative cost-benefit analysis. However, most of this analysis is limited to the costs of paperwork, legal and compliance review, technology enhancements, and the like. We found that, relative to other agencies, including the CFTC, the SEC's analysis was generally more thorough and included more quantitative analysis. However, there's still significant room for improvement. Of the 54 SEC rules we reviewed, 4 contained no cost-benefit analysis, 26 contained non-quantitative cost-benefit analysis, and 24 contained quantitative cost-benefit analysis, although of these 24 rules, only about half discussed any economic impact broader than paperwork, labor, compliance costs, and the like. The SEC has recently issued guidance to its staff that outlines best practices for economic analysis and rulemaking. We applaud the SEC for taking this step. The SEC has noted that analyses of costs cannot be limited to costs or to compliance costs or hourly wage rates. Broader analysis will usually require additional data collection and may necessitate that the SEC hire additional economists. We fully support the necessary funding for the SEC to obtain these resources. We are also pleased that the SEC has recognized the need to consider overall economic impact of its rules, including its rulemaking pursuant to congressional mandates as well as entirely discretionary rulemaking. Even where Congress mandates a rule, it is important to assess the costs and benefits of both the rule and alternative approaches. We note the SEC's approach here stands in contrast to that approach taken by the CFTC, and we strongly encourage the CFTC to rethink its position. The SEC has stated that in measuring the benefit of a regulation, it will look to the benefit of improving matters from the prior state of affairs, what it calls the pre-regulation baseline. We would caution that the agency cannot merely assume that a new regulation will necessarily avoid the past loss, as it could have been due in whole or part to matters not affected by or improved by the rule. We commend the SEC on its focus in assessing the trade-offs among reasonable alternatives to its proposed rules. Whatever the benefit of a proposed regulation, it is best to achieve this benefit at the least cost, and this can be determined by comparing alternatives. We've observed that regulators, including the SEC, have requested input on cost-benefit analysis from industry in many of the rules. We caution, however, that when a regulator does not receive the information it has requested, this does not relieve it of its duties to conduct cost-benefit analysis. Rather, there are numerous other avenues regulators can pursue. First, they may develop data. Estimates and data based on assumptions may serve this purpose. If the regulator is unable to develop data internally, it must obtain the information from third parties, for example, other agencies, self-regulatory organizations, trade organizations, or industry participants. Finally, regulators can request the data directly from firms that will be impacted by such proposed regulation. Any such data request should be made with an eye to minimizing the imposition on market participants. In closing, we recommend that with respect to any outstanding proposed rules that have been presented for comment but not yet finalized, the SEC apply its new guidance to these proposed rules, and the SEC has indicated it will do so. But the SEC must also review all of its final rules to ensure that they can withstand legal challenge. We note that approximately half of the SEC rules we reviewed were in final form, including rules with non-quantitative cost-benefit analysis. In closing, again, we commend the new direction the SEC has taken on this issue, and we hope that other agencies would follow suit. Thank you.
Thank you, Ms. McKay. Mr. Bullard.
Chairman McHenry, Ranking Member Quigley, members of the subcommittee, thank you for the opportunity to appear before you today to discuss cost-benefit analysis and SEC rulemakings. There is general agreement that in the past the SEC has afforded the economic costs and benefits of its regulations too little consideration. However, it has made significant improvements in this area, and it plans to make additional improvements in the future. In my view, the SEC is well on its way to establishing the kind of deeply embedded institutional processes that will ensure that economic analysis plays a central role in the agency's rulemaking. The Commission has hired a strong contingent of economists and plans to hire many more. Its Division of Risk Strategy and Financial Innovation now plays a key role in all rulemaking. Reports recently issued by the SEC's Inspector General paint a generally positive picture of the SEC's cost-benefit analysis in action. Nonetheless, I would like to address 4 concerns regarding the SEC's cost-benefit analysis going forward. First, I am concerned the SEC's cost-benefit analysis may become too focused on economic factors. Cost-benefit standards are naturally inclined to favor analysis that produces quantifiable, reducible results. Costs and benefits that can be monetized will generally be favored over those that cannot, because monetized factors can be more easily compared. They use a common unit of measure. For example, monetized estimates of compliance costs are consistently afforded disproportionate weight, not because they are more important, but because they are precise and reducible. As discussed in the OIG's report, Professor Kyle observed instances of this bias at work where micro-considerations were afforded greater weight and some macro costs were ignored or underemphasized. Second, the ultimate solution must lie with the SEC's lawyers. The lawyers exercise ultimate staff authority in the rulemaking process, and it is therefore lawyers who will decide the extent to which economic analysis is reflected in rulemakings. Lawyers tend to apply an overly legalistic analysis to what are ultimately non-legal issues. This problem can be mitigated somewhat by hiring lawyers with industry experience and expertise in business accounting and finance. The SEC should, and I believe already may, incorporate these criteria into its hiring practices. It should consider encouraging junior and senior staff to leave the SEC to obtain industry experience while seeking out lateral hires from industry to replace them. Third, the Commission should attend to the risk of administrative paralysis. The rulemaking process, like any forward-looking process, is inherently uncertain. It is necessarily based on incomplete information, and cost-benefit analysis is ultimately inherently subjective. Many criticisms of the SEC's cost-benefit analysis simply reflect unreasonable expectations. The Commission must ensure that it does not avoid rulemaking altogether out of fear that its rules will be attacked and even vacated by courts. And finally, the Commission should consider reforming the rulemaking process to be more like the creative, somewhat risk-taking process that it is. In my view, any cost-benefit aversion the SEC may have may be more a reflection of a 20th century workplace culture in charge of regulating a 21st century industry. Although some rulemaking initiatives are preceded by a concept release, most begin with a commitment of a team to the goal of producing a proposal. But it is not really a proposal, at least not in the sense that a business would develop internal proposals for a new business initiative. It is a full-blown rule based on extensive analysis and a set of assumptions. It reflects the incorporation of different viewpoints, but not in the sense of competing viewpoints. It is subject to change, but it still reflects to some degree the vested interests of its creators, including cost-benefit analysis done by economists. The Commission should consider workplace processes that will produce more robust collaborative analysis. For example, it could issue initial précis, a short umbrella proposal that outlines the problem, lists potential solutions, and makes a first cut at the types of costs and benefits that it expects the proposal to implicate. Before deeper analysis has been conducted, substantial resources have been committed, and vested interests have begun to set. It could issue multiple proposals so that, as with movies with multiple outcomes, there's a genuine doubt as to how it would end. Proposals are often viewed as positions from which a commission must be moved, as if anchored to vested staff interests. Multiple proposals could be issued by competing teams within the SEC, created through a competitive process. Rulemaking staff could submit their own proposals that, if approved for further development, could entitle them to devote a certain number of work days to take it to the next level. The staff could appoint red and blue teams, whose job it would be to tear apart proposals in mock cost-benefit challenges. For example, the staff has 270 days to adopt rules for crowdfunding that address 15 or 20 or so requirements. Why not start by assembling the entire rulemaking staff in trading and markets and give each one 2 hours to sketch out the essential elements of the rules, then have to present their ideas to a group for a no-holds-barred brainstorming session? A series of face-offs could winnow down the pile, with winners allowed to cannibalize elements from their defeated opponents' proposals, or maybe put them all on a remote island where one is voted off every day. When I see pictures of successful startups' offices engaged purely in the business of creating intellectual property, they are not working in separate offices or even separate cubicles, but lined up in a row at a long table, elbow to elbow, much like, and not coincidentally, the trading desk of large broker-dealers. The SEC is also engaged in a kind of collaborative, complex intellectual property creation, as am I as a law professor and as are members of Congress as lawmakers. What should our collaborative, complex intellectual property places look like? Probably not the way they look today. In conclusion, rulemaking is, no matter how thoroughly analyzed by economists, a venture into the unknown. It is a creative process in which one must assume, indeed embrace, the risk of getting it wrong if change can ever happen. Let's ensure that all reasonable costs and benefits are considered before acting, but let's not impose so many burdens that action becomes impossible. Thank you again for inviting me to testify, and I would be happy, of course, to try to answer any questions you might have.
Thank you, Mr. Bullard. Mr. Vera.
Chairman McHenry, Ranking Member Quigley, and members of the committee, I really appreciate the opportunity to join you today. As mentioned, I teach corporate and securities law at George Mason Law School and am a senior scholar with the Mercatus Center. In September of 2011, I had the opportunity to testify before the House Committee on Financial Services on this issue. SEC staff and Chairman Shapiro were present, and it was argued there that economic analysis is not always required when rules are mandated under legislation. And in any event, measuring the impact of new rules can be prohibitively difficult. I'm aware the staff have prepared a memo that represents an about-face in terms of this thinking. I want to congratulate the Commission and the staff and Chairman Shapiro and this committee and the various oversight committees of Congress and, frankly, the judiciary for their oversight on that issue. It remains to be seen whether this new memo is just a memo or it would be put into place in future rulemaking. After a careful review of the legislative requirements that the SEC consider investor protection, efficiency, competition, and capital formation in adopting new rules, I'd like to offer a list of eight items that I think would demonstrate a sincere commitment by the SEC to fulfill its statutory mission in this regard. The first 5, in fact, are mandated by law, if one carefully reads the judicial interpretations in the legislative history of this issue. I offer this list as a test of their resolve, the SEC's resolve, to make economic analysis a sincere constraint on SEC rulemaking and a limit on any political pressures it might face to politicize its activities in a way that might undermine investor protection. First, rules must have sunsets and look-back requirements when the agency represents in a rulemaking that costs and benefits are difficult to estimate, as it represented in rulemaking pursuant to Section 404B of Sarbanes-Oxley. At times, data relevant to rules' costs and benefits might not be available until years after implementation. When this is true, as it was under Sarbanes-Oxley 404B, where the SEC initially estimated implementation costs of $90,000 per company, later estimated at $1.8 million per company, sunsets and look-back requirements that automatically stop the rule and urge a reconsideration and readoption of the rule are necessary. Number 2, the SEC has to consider the costs of a new rule against any alternatives advanced by a dissenting commissioner. This is required under various interpretations from the D.C. Circuit. Number 3, mandatory disclosure rules must be subject to the same materiality standard as private plaintiffs in 10b-5 cases. A disclosure not material to investors cannot be legitimately said to further the goals of investor protection. 4, the agency must in order to meet its requirement to consider the impact of a rule on competition, capital formation, and efficiency, estimate the impact of a rule on the competitiveness of U.S. exchanges against foreign exchanges for new listings, the competitiveness of U.S. issuers, the risk that proprietary information might be revealed, and the impact of a rule on the stock prices of effective companies. The agency must also estimate the impact of a rule on items like job creation and GDP, economic factors in sum. 5, the agency must retract and repropose rules advanced pursuant to the Dodd-Frank Act to reflect the agency's new policy on cost-benefit analysis and its about-face shift on this issue. The SEC's rule proposal under Section 1504 of Dodd-Frank is a case in point, where it fails to consider the impact of disclosures on the risks that it will reveal proprietary exploration plans of U.S. energy companies. 6, the agency has to freeze attorney hiring until it hires at least 200 more economists. And I know that sounds like a lot, but in fact it's not when you compare the SEC against its sister agencies. The FTC staff, very similar market-based mission. In fact, the securities laws were originally placed in the jurisdiction of the FTC in 1933 until the SEC was created in 1934. The FTC has about 10% PhD economists. The CFTC, it's less than 5%, and at the SEC, that number is less than 1%. 10% at the FTC, less than 1% at the SEC. In order to be on par with sister agencies like the FTC, the SEC has to hire at least 400 new economists. I think 200 would be a modest commitment in this regard. The fact that it has misallocated resources in the past should not justify added appropriations, but instead suggests a need for reallocation of present resources. 7, the Division of RISC-Fin should get authority in rulemaking. And I know the Chairman has indicated in testimony today and in the memo they've indicated that this is the case. But until I see a changed SEC internal official operating procedures, I question that observation, the continuance of that observation. Number 8, the RISC-Fin must be given a role in rating the impact of cases brought by enforcement lawyers in their personnel reviews. The agency's existing metric, which focuses on size of recovery and number of cases resolved, can distort incentives and lead to missed opportunities to stop ongoing fraud like that seen in the Madoff case. If we had economists measuring the rate of fraud, for example, one example, the rate of fraud prior to a case being brought, we can estimate the rate at which it grows and estimate the amount saved to investors. And I think that, though the internal enforcement staff will be resistant to this, it could be very beneficial. So I thank you for the opportunity to testify, and I really look forward to answering your questions today.
Mr. Kotz.
Thank you. Thank you for the opportunity to testify before this subcommittee. I served as the Inspector General for the SEC from December 2007 through January 2012. I'm currently the Managing Director of a private investigations firm called Griffin Strategies. Prior to my leaving the SEC on January 27, 2012, my former office issued a report entitled Follow-up Review of Cost-Benefit Analyses in Selected Dodd-Frank Act Rulemakings. In connection with this report, we retained an expert, Dr. Albert S. Kyle, to assist with our review. In this review, our objectives were to assess whether the SEC was performing cost-benefit analyses for Dodd-Frank rulemaking initiatives in a consistent manner and determine whether problematic areas existed and where improvements were needed to enhance the overall methodology used to perform cost-benefit analyses. In the course of the review, we learned that when questions arose in 2010 about the extent to which cost-benefit analyses should be conducted for Dodd-Frank Act rulemakings, rulemaking teams and the Division of RISC-Fin consulted with the then SEC General Counsel. On September 27, 2010, following these consultations, the former General Counsel, in a memorandum to rulemaking teams and RISC-Fin, advised that where the Commission has a degree of discretion, the release should discuss and attempt to quantify the costs and benefits of the choices. However, where the Commission has no discretion, the memorandum advised that the release should say so, and that because the Commission is making no policy choices, there would be no choices to analyze or explain. We found that the approach articulated by the former General Counsel dovetailed with the approach utilized by the SEC rulemaking teams in the cost-benefit analyses we reviewed. For example, the introduction to the cost-benefit analysis section of the adopting release for the shareholder approval of executive compensation and golden parachute compensation rule stated the following. The discussion below focuses on the costs and benefits of the amendments made by the Commission to implement the Act within its permitted discretion, rather than the costs and benefits of the Act itself. The January 27, 2012 report describes how, pursuant to OMB guidance, a cost-benefit analysis, is intended to inform the public and other parts of the government, including Congress and the regulating entity itself, of the effects of alternative regulatory actions. This OMB guidance also specifies that agencies should establish a baseline for use in defining the costs and benefits of alternative regulatory actions, and the baseline will be a no-action or pre-statute baseline. We found that to the extent that the SEC performed cost-benefit analyses only for discretionary rulemaking activities without a pre-statute baseline, the SEC may not be providing a full picture of whether the benefits of a regulatory action are likely to justify its costs and which regulatory alternatives would be the most cost-effective. In addition, based on an examination of several Dodd-Frank Act rulemakings, the review found that the SEC sometimes used multiple baselines in its cost-benefit analyses that were ambiguous or internally inconsistent. The review also found that there was often considerable overlap between the cost-benefit analyses and efficiency, competition, and capital formation sections of the releases for Dodd-Frank Act regulations, and that such redundancy could be reduced by combining these two sections. Further, we found that some Dodd-Frank Act rulemakings lack clear, explicit explanations of the justification for regulatory action. The report found that a more focused discussion of market failure in cost-benefit analyses would lay out the rationale for regulation more clearly to Congress, the general public, and the SEC itself. Finally, the review found that although some of the SEC's Dodd-Frank Act rulemakings may result in significant costs or benefits to the Commission itself, internal costs and benefits were rarely addressed in the cost-benefit analyses. Based on the results of our review, the report made several recommendations for improvements to the SEC's practices. These recommendations included, 1, considering ways for economists to provide additional input into cost-benefit analyses; 2, reconsidering the approach that the SEC only perform cost-benefit analyses for rulemaking activities to the extent that the SEC exercises discretion; 3, using a single consistent baseline in the cost-benefit analyses; 4, discontinuing the practice of drafting separate cost-benefit analysis and efficiency, competition, and capital formation sections; 5, directing rulemaking teams to explicitly discuss market failure as a justification for regulatory action in the cost-benefit analysis of each rule as appropriate; and 6, including internal costs and benefits in the cost-benefit analyses of rulemakings. While I left the Commission shortly after the report was issued, I understand that the SEC has now taken significant steps to implement the report's recommendations. Thank you again for the opportunity to testify, and I will be happy to answer any questions.
I thank the panel, and with that, I'd like to yield to my colleague, the ranking member, to ask questions first. Mr. Quigley.
Thank you, Mr. Chairman. Ladies and gentlemen, as I listen to your testimony, I'm struck by the questions I asked the Chairman, and that is, this is important and very dry, mind you, but you get stuck with the emotional aspects and the real-world pain caused by what happens when we don't capture this WorldCom, Enron, Madoff, and the 2008 crisis. Dr. Mann, is it your assumption or your belief that those are happenings that regulation couldn't have caught, that a good regulation or good practice wouldn't have caught? I mean, could an economist catch that, or was, where did we miss that? And isn't that our main concern when we determine what the benefit is in a cost-benefit analysis? Doctor, how do you measure the thousands of people who were pained and the millions of dollars that were lost when you do, in your minds, a good cost-benefit analysis? Yes. Sorry.
Well, I think there certainly may be aberrations all over the place. Some of the episodes you mentioned can partially be put at the foot of the SEC, some of it elsewhere. Some of it is omission, certainly in the case of Madoff, that seems to be clear. Others of it may strangely be results, unforeseeable results of actually regulations in effect. There's a very strong view, for instance, that if insiders in a corporation were allowed to engage in insider trading instead of doing whistleblowing, the Enron thing wouldn't have shown up. because very early on, people would have made a lot of money by, in effect, letting that information out into the market by selling shares. So there are a variety of different ways. And that brings me to the point of this discussion, that there are many different forms of economics. I made the point about cost-benefit analysis being merely one form of analysis. There are economists, and then there are economists. The SEC could hire 200 economists whom I would not think qualified really to do the job I want them to do. A lot of it, I think the heavy work still remains not in the cost-benefit and empirical data business, but rather in terms of getting the analytical model straight. I don't think that anyone has ever devoted themselves to that kind of problem in connection with this regulation.
And Doctor, let me move on because I have somewhat limited time. Mr. Barrett, could you comment? I understand your answer and what you talked about in your 5 minutes, but you know, how do you measure what the benefit is if the risk could potentially be so great?
I think you have to do the best job you can to measure the costs and benefits, and you know, that may be a dry phrase. I think you can rephrase it accurately to be the regulatory taxes that get passed through to American consumers, American investors. And one way that we've estimated this is with respect to the first rulemaking the SEC did pursuant to Dodd-Frank, the rulemaking that was struck down in the D.C. Circuit case, the Business Roundtable case. And my co-author, Professor Stratman, and I are publishing an article, a peer-reviewed article in the Stanford Law Review that estimates just a small subset of the firms that were affected by that rule. So, in fact, the proxy access amendment to Dodd-Frank requires the SEC to consider the impact on small firms. The SEC did not, and consider an exemption for small firms. And the SEC, despite the will of Congress, the SEC did not provide an exemption for small firms. We measure what impact did that have on small firms. The rule was just delayed a couple of years for them rather than a full exemption. We find it caused almost $500 million in shareholder losses just for that small group. And you extrapolate that out to all the companies affected by that proxy access rule that was struck down by the D.C. Circuit, we're talking about billions of dollars in regulatory taxes. So I think it's important to estimate that and to include it at the benefits of preventing you know, long-tail risk. But I wouldn't always assume that regulations are going to prevent it. I mean, Sarbanes-Oxley certainly didn't prevent the financial crisis of 2008.
Sure. Mr. Katz, let me throw in this quote from Chairman Greenspan's testimony before the full committee. He said it was a mistake to presume, quote, that the self-interest of organizations, specifically banks and others, was such that they were best capable of protecting their own shareholders. Getting to the points I raised before, how do you strike this balance? I understand, as you suggest, that we want to avoid ambiguity, overlap, and redundancy, and we need to do this as best as we possibly can. I mean, how much faith do you have in the market policing itself that we don't need to be very strong, the SEC doesn't need to be very strong with its regulatory measures to protect the public?
Yeah, no, absolutely. I think that the SEC needs to be strong, and that's the reason why it's so important to do a thorough cost-benefit analysis, to look not only at the costs but also the benefits. There are situations where there is market failure, and one of the points that we made in the report was the SEC should point that out and explain that. So our focus in the Office of Inspector General report was to ensure that they do the best job possible to look at the benefits that you articulated as well as the costs.
Mr. Bullard.
I thought the question was about fraud, and I was looking forward to Professor Barrett explaining his rate of fraud analysis. I'd be interested how one can quantify the cost of the rate of fraud. It's an extremely difficult problem I've found, and one is exactly the kind of benefit of regulation that's hard to put your finger on, and that economic analysis invariably downplays. I also can't help but respond to Dr. Manny's analysis. His insider trading analysis I found to be brilliant, but the fact is Enron executives were selling, and they weren't telling anyone, and one of them stood in front of a room full of employees and told them that they should buy more shares as the company was sinking, and those people testified before committees of Congress about how their entire retirement had been destroyed. And in fact, fortunately, this country has never adopted the idea that insider trading should be a permissible course of action. So I think it's a classic example of where economics takes you if you don't also consider the social construct within which law is made. The problem from an investor advocate point of view, Ranking Member Quigley has put his finger right on the point, which is it's extremely difficult to quantify what the cost is when an 85-year-old man suffering from dementia is sold a variable annuity, or when somebody who has a $20,000 income is defrauded in a $2,000 offering over the Internet. That's tough to measure. If someone has a quantification analysis they can provide that will allow the SEC to do that, then I would like to know about it. But the SEC has to be allowed to make those calls. That's its job. It's the job Congress gave it to do. And at some point, the cost-benefit analysis requiring quantification of every piece of analysis makes that virtually impossible to do.
And Ms. McCabe, I don't want to be rude. Please, I have limited time, but please, if you give us your thoughts.
Sure. Yes, just very briefly, I acknowledge that the benefits of different rules will be certainly difficult to measure, but as I mentioned earlier, I think it's important that the analysis not be conclusory, and we don't assume that a regulation will have a benefit equivalent to the value of the crisis that had occurred prior to the regulation. And secondly, and I discussed this more extensively in my written testimony, but there are rules like the Volcker Rule, for instance, proposed by 5 different agencies with 5 different sets of cost-benefit analysis requirements with 0 cost-benefit analysis. So, again, would just encourage that there needs to be thoughtful cost-benefit analysis.
Thank you, and I appreciate your efforts, and the Chairman for letting me speak. I need to get to the floor. Thank you.
I certainly thank my colleague for his questions. It's a fascinating subject matter, and certainly appreciate the answers and the testimony this panel has given. Mr. Kotz, I want to begin with you. And now you were the former Inspector General for the Securities and Exchange Commission, and certainly appreciate your service in government. Thank you. Especially the final report before you went to the private sector. In your final report, you call into question the cost-benefit analysis and the use of it with the Securities and Exchange Commission. Out of that report, Chairman Issa and I wrote a letter to the Securities and Exchange Commission, and they've acted relatively quickly in the world of the Securities and Exchange Commission with new guidance, incorporating many of the provisions that you called into question. The solutions to those issues you called into question, and answering a number of the concerns that Chairman Issa and I have about the importance of cost-benefit analysis to all rules that go through the whole process. So I want to thank you for that. Thank you. You've done a good service for your government to draw this report to people's attention and actually getting a change based upon a good work.
Thank you.
So in discussion with that, how much time, you reviewed the Securities Exchange cost-benefit analysis and the cost associated with their failure to follow the letter of the law and the direction of Congress and the regulatory cost and the staff time. Can you discuss that cost of their failure to use cost-benefit analysis, the cost to the taxpayer and to market participants?
Yeah, but we didn't quantify it specifically, but clearly if you have a regulation and you just assume without doing a cost-benefit analysis that the benefits outweigh the costs, and you don't provide that information to Congress, to the public, then you set up a situation where the information isn't out there about whether this regulation is useful or not. And that's something that is a concern. In my time as Inspector General of the SEC, there have been occasions where we found that there were certain rules put into place, and the rules required certain disclosures, certain filings. And yet the documents that were filed were not really used by the SEC. They were put in a drawer. And so you have certainly a cost that is associated with it on the part of a company, for example, in having to do this filing, but then you don't have really any use of it by the SEC. And so notwithstanding the fact that it was mandatory or whether the SEC had any discretion or not, it's very important for the SEC to assess that. And if they don't assess that, then Congress doesn't have the information to know whether this rule that was put in place is actually working and is actually cost beneficial.
Is there a need for a wholesale cultural change in order to incorporate this, the cost-benefit analysis at the SEC?
I mean, I think that this March 16, 2012 memo is a very good start. I mean, that is, as you said, it really changes the way things are done, completely. the differences between the Becker memo that you discussed before that I mentioned in my testimony and this one are very great. So, I mean, I think the proof will be in the new rules. You know, clearly I'm not the Inspector General anymore, but if I were, I would certainly look at the new rules to make sure that it's not just guidance that is put forward, but that there's actual application of that guidance in the new rules. I do think that if the SEC, when they issue the new rules, follow the latest guidance as opposed to the Becker memo, I think you will see a significant difference in how they do their cost-benefit analysis.
So, Mr. Bullard, is that an essential ingredient to rulemaking, a cost-benefit analysis?
Yes, absolutely. And I think that one thing we could probably all agree on is that by the end of the year, we'll probably be able to say that Chairman Shapiro has done more to improve cost-benefit analysis and SEC rulemaking than every SEC chairman in history combined. And I think those are critical steps.
I'd like that to be the case.
Yeah,
I would like that to be the case.
I think you might even be able to say that today. I agree with my other panelists that historically this has been a major inadequacy, and Dr. Manny is one of those leaders in moving the SEC toward much more economic analysis. But I would like to just warn my colleagues, speaking from having been inside the SEC, hiring more economists is not going to fix the problem any more than hiring more workers would change the architecture of the pyramid, right? You've got to get the lawyers on board. And as I noted in my written statement, part of the problem is our American legal education, is that lawyers do not have the competence in business, finance, accounting, and industry in order to do the job. And I think the SEC is already, based on my anecdotal experience, doing something to hire people with more of that kind of experience. But it's got to be the lawyers. The economists alone won't do it.
Is this really, with all due respect, is this really a moment to insert a lawyer's joke? Because I think it might be.
Feel free.
I think it really might be as a non-lawyer.
I would take this opportunity to emphasize that at George Mason Law School, founded by Dean Manny, we have, as part of the first-year curriculum, an economic analysis course for law students, and we do have law students interested in working at the Securities Exchange Commission.
I knew that pitch was coming. I just knew. But you know, for half the price, you can go to Ole Miss and get a law degree as well.
Well,
speaking of economics,
Mr. Bullard, are you trying to change the culture of Ole Miss so that they actually, you know, your lawyers come out?
Well, I'm not trying to highlight Ole Miss, and I'm not suggesting that there isn't more that I could do personally, and I always strive to do more personally in order to integrate these issues into the curriculum. But there is a major systemic problem in American law schools.
But and it's also a cultural problem.
Is a cultural problem. It's an aversion.
Right. So this process, and I asked Chairman Shapiro about this, I said, in essence, does the economic analysis, the cost-benefit analysis, can that be a veto?
Yeah, right? I was interested by your question because it depends what veto means. I think the Chairman was fair in trying to get at that. But
she was saying that it has to be signed off by RISC-Fin, and so you're going to have the economists sign off on rules, which I think is structurally a very different concept than what we've seen, as you said, with SEC over the last, you know, let's just say 50 years. We could say 80. But, Dr. Manny, you know, in terms of this discussion, you've followed this extensively, obviously. But when we have this discussion about a market failure, right, this has been used, this was, you mentioned this in your testimony. It's been mentioned a couple times on this panel. How common is a market failure, just to understand this discussion?
Well, as I said, there are economists and economists. My own sense about it is that true market failures are extremely rare, and particularly among some of the kind that are listed in the March 16th memo. For instance, they talk about market power. I presume they mean monopolistic organization of the market. Well, that's a very unusual kind of market failure for the SEC to confront. Historically, they supported the most famous market failure of all, and that was the fixed commission rate structure in the New York Stock Exchange for many, many, many years. I couldn't really think even of what they had in mind in that connection. Then they talked about negative and positive externalities. Now, that's sort of a cop-out because it was in the context of explaining when it would be difficult to get good quantifiable data on these externalities. And that's why I say that that kind of thing, if you assume that a negative externality is a market failure, you start regulating to prevent the externality, you can make a big mistake, because the market almost always finds a solution to these negative externalities, just as it does to the problems we talked about, I mentioned before, of asymmetric information. The most famous work on that subject is by a man who got a Nobel laureate in economics, David Akerlof, who talked about the market failure in the market for used cars. And he theoretically showed that if systematically people don't have good information, that the entire market could collapse for what is obviously an economically good product, but people wouldn't have the information and therefore the market would collapse. Well, the odd thing about it is that when that lemons problem is mentioned over and over and over and over again in economics, very few writers even notice the market had already provided a solution to that problem before Akerlof even identified it. There was no failure in the market of used cars, and that's the same thing here. If they talk about asymmetric information, the market deals with those issues, maybe in ways that we can't even project at this point. But that's the virtue of a free market, that new innovations will constantly come up. And if there are real costs, the market will always provide a good solution.
So to that question, and this is a discussion, Mr. Bullitt, I asked you this when we had our crowdfunding hearing, with securities regulation, no matter how perfect the rulemaking of any regulatory body, there will be fraud in the marketplace. Does the whole panel agree? Actually, should I say, do you disagree? Okay. So with this, all rules, all securities regulations bear a cost, do they not? Okay. So everyone agrees. Okay. And with some, I don't know if it's all, but with some, there are benefits that outweigh those costs, right? Okay. So I just want to make sure that we're all in agreement. There's no sort of disagreement with those basic notions of this when we have this discussion. Mr. Barrett, you mentioned, you ticked through a number of interesting pieces with your testimony. And you talk about a few recommendations, and you note that the first 5 of these recommendations are already existing law that the Securities and Exchange Commission is required to abide by, right?
Yeah, particularly in the 5th one where I mentioned reproposal, maybe not necessarily every single rule, but any rule that doesn't abide by the operating guidance and the about shift in the agency's position, I think has to be reproposed, absolutely. Runs a very high risk of being overturned in the D.C. Circuit.
Okay. And so what is the time frame that they should undertake in order to do that?
I think that they should address these issues in the memo right away would be my suggestion.
Okay.
And also, in addition, change SEC operating procedures to delegate authority to risk fin. The agency frequently delegates authority within its operating procedures to the various divisions, and I would suggest keeping an eye on whether the SEC does any actual amendment to its internal operating procedures with respect to risk fin's authority.
Interesting. So what you're suggesting is that the SEC needs to go back through their existing regs
and delegations of authority in the operating procedures, internal operating procedures of the Commission.
Mr. Kotz, in your experience with the SEC, that seems very far-reaching what Mr. Barrett just suggested.
Yeah, I mean, I don't know that the SEC plans to go back and look at the regulations that they already did. I mean, I think the Chairman seemed to indicate that they would not. So, I'm not saying anything about the idea, but I don't know that that's actually going to happen.
I was referring to the operating procedures of the SEC.
The operating procedures.
Certain authorities are delegated to the Division of Corporate Finance or IM or something of that nature.
Okay. Okay. So not full scale, all the regs that are on the books.
Although I won't say that there aren't regs on the books that are subject to significant challenge, just as Business Roundtable was. And frankly, I would question the SEC's taking credit for regs that aren't challenged, because not everyone has the funding to challenge. It's very expensive to challenge a regulation in the D.C. Circuit. I'm sure that was very expensive, and typical average investors don't have the funding to go all the way through a D.C. Circuit challenge necessarily.
Ms. McCabe, in your testimony, you outlined that 192, if I find my notes correctly, 192 proposed rules across the government are required by Dodd-Frank, and it appears that the great majority of these rules either had no or deficient cost-benefit analysis performed on them, according to your testimony, according to the work that you've done. Could you go into some detail about the problems that you found in the study you performed?
Sure. And just to clarify, it was 192 of the proposed and final through last November that we looked at, so obviously there will be more eventually. So, and we didn't attempt in any individual case to really weigh in on whether we thought the cost-benefit analysis was adequate or inadequate. We tried to keep it very objective, and obviously in some cases where there's no cost-benefit, for instance, clearly would be inadequate. In the rules with no cost-benefit analysis, a number of rules referenced that OMB had provided analysis, but the rules themselves contain no detail, which again I think doesn't absolve the issuing regulator of their responsibility. Other rules we found suggested that cost-benefit analysis was not required because the rules were not discretionary, and we've seen the SEC sort of reverse course on that issue at this point. Regarding the rules that have non-quantitative cost-benefit analysis, we saw a number of rules where regulators simply stated cost-benefit, and they expect costs to be insignificant or minimal, and just said that in a conclusory way with no further explanation. And then, again, of the rules with quantitative cost-benefit analysis, again, we didn't look specifically at whether the quantitative cost-benefit analysis was adequate, but the vast majority contained just compliance, labor, technology costs, and that sort of thing. And where there is quantified cost-benefit analysis, it in many cases would relate only to one aspect of the rule or to one specific question in the rule, and it wouldn't be an overall view of the economic impact of the rule, which is clearly what the cost-benefit analysis is aimed to get at.
So to this point, I mean, in essence, the practice we see from regulators is to only do basic fixed costs that are the easiest to analyze, paperwork functions and.
In the vast majority of cases, yes, that's right. What we found.
So they wouldn't analyze, for instance, the impact of a company to go public. That would not be something that is in most of these.
That's correct. I mean, I'm speaking in generalities again, but yeah, I mean, there were a few instances where there were attempts to look at broader economic impact of a proposed rule, but it tended to be focused on, a single aspect of the rule, not sort of looking across the board at impact.
So with the Jobs Act, right, which is the largest rewrite of securities laws in, well, since the 1970s, by any fair view. With the Jobs Act, which is in essence so much about securities regulations, the essential parts of this bill are securities regulations. The impact on the ability of a small company to go public, and this is not just Sarbanes-Oxley, it's a whole litany of the regulatory processes, that in essence we price out the ability for small companies to go public.
Sure, that would be one piece.
And so there's no really duty for a regulator to even be concerned, with the SEC to even be concerned about the impact they have. So we have fewer companies, fewer IPOs than we did a generation ago. We have fewer public companies than we had a generation ago. And in essence, we have the Securities and Exchange Commission say that is of no cost. Is that basically the practice we're seeing, Mr. Barrett?
I think it is a fair representation of the practice, and I think it violates the SEC's obligations under the 96 amendments to NISMIA, to the National Security Markets Improvement Act, the required consideration of efficiency and capital formation in particular.
So how do we fix this?
Well, I think
just
that
beyond cost-benefit analysis, obviously. This is certainly an ingredient, don't you think? But what else would you?
Well, I would continue to urge the 8 suggestions that I've given for consideration. I would urge a more expansive view of economic analysis along the lines of what Dean Manning suggested, that you look at empirical observations when they're available and when they're useful. You look at non-empirical but still economic concepts when they're useful, the ability of parties to transact around things. But you're not permitted to look at non-economic variables. So despite Professor Mercer has argued in favor of that, but the 96 NISMIA amendments, not only just on their face, but in the legislative history, make clear that isn't at all what was intended. So if you want to talk about a new statute, maybe that might be an interesting debate we could have, but under the present rules, it's not permitted. But to do the best job you can, I mean, I would try to urge continued investment in the economic analysis function at the SEC, giving it more authority and transferring resources from other places to there.
Okay. So we've got a number of questions, but one final question from me, then I've got a broad request for the whole panel. If the SEC fails to require both PCAOB and FINRA to adhere to these updated guidelines for incorporated cost-benefit analysis, do you think that is a regulatory failure? We could begin with Mr. Kotz and go across the panel.
But that wasn't a specific area that I looked at, but it would seem as though that would be a significant problem, certainly.
To not include FINRA and PCAOB?
Right.
Okay.
I would classify that as a regulatory failure. And I'm aware that this item is, I believe, included in the SEC Regulatory Accountability Act, which I think goes a long way toward getting at this issue. And I would also urge consideration of the impact of not only on SROs, but the impact of preemption on the state law-based incorporation system and the competition, and the market, the innovations around market failure that take place at the state level that the SEC can at times impede by preemption.
Mr. Bullock.
I'd like to look back at the actual SEC authority to oversee FINRA in that way before answering that question. It is not immediately clear to me that they can delve into rulemaking in that way. As a matter of policy, I think they should attempt to impose those standards, but I can't say offhand whether legally they have the authority to do so. And I also want to note the Chamber of Commerce has directly commented on the issue of FINRA's cost-benefit analysis and was very critical of it. Yet, the House Financial Services Committee, probably either this week or next, will be dropping a bill that will create an entire new SRO that will not be subject to these cost-benefit analyses. And it will raise exactly the issue that you're raising here today.
That bill, by the way, has not gone through the markup process, so you'll hear otherwise.
I would comment that the committee, in its comment letter on the PCAOB's proposed rules on audit firm rotation, discussed this issue specifically and said that the SEC, having oversight over the PCAOB, should encourage more thoughtful cost-benefit analysis. In that rule, again, there was very minimal analysis.
Thank you. Mr. Manning.
I would like to address a tangential aspect of that, and that is that in anything the SEC does, under the present jurisprudence given down by the Supreme Court in the Chevron case, the courts often simply dodge really overseeing this task in the sense of giving deference to the agency's discretion. This is particularly true if the agency shows up with a highly complex mathematical cost-benefit econometric study. I think that congressional legislation beefing up the standard the courts ought to use in reviewing these agency rulings would be very much in place. I think an increase in civil actions complaining about errors and mistakes made in various cost-benefit analysis or other economic analysis would certainly be true. I would have a review of not merely the coming rules that are on the floor now. I would have them go back over many years and do a different kind of analysis than they did. There's very, very little academic work over many years empirically justifying the vast bulk of rules that the SEC has promulgated. Maybe they ought to be looked at. Maybe the findings would be of a different sort. Finally, I would suggest, and this is the hardest one of all, that the agencies, in explaining the economic rationalization of whether it's cost-benefit analysis and econometric analysis or whatever, they be required to do it in plain English. I don't think there's any good economics that cannot be understood in English, but I think that lawyers and judges, for some good reason, some bad reason, simply can't handle the level of sophistication in mathematics and complex economics that economists engage in among themselves. And it would be tragic if that was used as a cover-up for what was going on here. Fascinating.
Well, it's an interesting perspective that you share here today. You know, I typically like to end the hearing when we have a moment to ask a broad question of what we can do to fix the state of the economy today. Now, we're talking in light of securities regulations. If there's one thing that we can do that you would recommend, and if you don't want to engage in it, that's fine, you can pass, but this is the one opportunity to say, here's one interesting thing we could do to update securities laws that would have a beneficial impact on the economy. So we'll start with Mr. Kotz, and if you want to pass, I certainly understand. I know you've moved to the private sector. But
I would just say that, you know, I think the issue we're talking about today is important. You know, I mean, clearly when you have a problem, the financial crisis, there is an interest in deciding to put forth regulations to try to fix that. But I think we need to figure out whether these make sense, whether they are actually beneficial, and I think that would help benefit the overall economy and things as we go forward.
Mr. Barrett?
I would suggest that, you know, I think one of the fundamental ironies of securities regulation since its inception in the 30s has been that securities regulation is designed around the idea, and the SEC has always assumed, that investors are intelligent and sophisticated enough to be able to process the mandatory disclosures that they get, but they're not intelligent and sophisticated enough to exercise choice in opting out of those disclosures, or any other rules for that matter. And specifically, I would consider the issue of securities or permissive securities arbitration in charters of companies going public. The Carlyle Group tried to insert one and was very quickly beaten down by institutional investor groups and by the SEC to allow shareholders the choice of opting for securities arbitration rather than securities litigation. And the SEC would have none of it. I think it's something worth considering. I think there's something to the securities litigation system, of course, and you know, to tinkering with it and reforming it. But I think there's also no reason not to give investors the choice to opt out of it altogether.
Well, in essence, the market, not to interrupt, but the market has already spoken. If you look at Facebook, those folks that had the opportunity to invest, they're actually foreign investors that invested through Goldman's conduit. Mm-hmm. To invest in a privately held company. That means they didn't get all the mandated disclosures that a public company would have to give, and yet they were able to raise billions of dollars worth of capital for a privately held company outside of those mandatory public disclosures. So it seems your point is very fascinating, because it seems as though the market has looked for a way to opt out in certain circumstances. Mr. Bullard.
Yeah, I actually have somewhat related comment to the sophistication issue. You know, there's always been a longstanding problem with the disclosure regime, and that what triggers being a public company is essentially sales to unsophisticated investors. And the way the structure of the law responds to that is to give them company-specific information that not allowing them to buy in private offerings assume they can't handle and make decisions on the basis of anyway. So there is a deep sort of contradiction in the whole structure, where one should really think that if those investors are allowed to invest at some point, it should be diversification and sort of basic ideas of, what nature of risk you're taking on when you're investing in this company, not company-specific information that the regulatory structure assumes that they are least capable of doing, and that by engaging in that market, they are most likely to lose their shirts. So my approach to that would be more try to move away from disclosure regimes, increase private markets, and at the same time shift the extent you're going to have regulation protecting investors to the intermediary stage. It's much more efficient to do there, and we had that discussion in connection with crowdfunding, the idea of the fixed costs and standardization happening at one place rather than lots of different issuers saves everybody a lot of money, and I think it's much more consistent with the idea of protecting the people that you want to protect.
Thank you. Mr. McCabe? And I'm not sure if in your position you want to advocate anything beyond that, but you're more than welcome to.
Thank you. That's exactly what I was going to say. As I'm speaking today on behalf of the committee, I can't really, speak to a single issue that would be most important to everyone on the committee. But I would like to echo former Inspector General Kotz's comments that we have long believed that thoughtful cost-benefit analysis would really benefit and improve the competitiveness of the U.S. capital markets, which is obviously the long-time cause of the committee. Thank you.
Thank you. Dr. Manning.
I'd like to see some real beefing up of judicial review of regulatory actions, whether that would take the form of overturning the Supreme Court's case in the Chevron case, or simply affirmatively mandating that the courts do review these things. In time, I think we can solve a lot of the technical problems of cost-benefit analysis by building up a kind of common law of what is good analysis and what's bad analysis. I don't see any agency other than the courts that could do that. Now, courts tend to fight off these highly technical cases, but we have schools for judges. We can help them in many ways. And as far as I can see, that's the last possible monitor to really ratchet in this thing and guarantees that it builds in the right direction.
Well, Mr. Verrett wants a mulligan here.
Yeah, I just want to add one more little second observation, if I can pick two things for Christmas rather than just one. Is reconsideration of an item in the Dodd-Frank Act that I think actually points out an inconsistency, a very strong inconsistency in the Obama administration's rhetoric on a number of items recently. The Obama administration has emphasized with, for example, the Buffett rule, an increase in taxation on individuals making more than millionaires, essentially. Well, a little-known provision of the Dodd-Frank Act, signed by President Obama, actually secures and maintains special investment opportunities in private equity funds and hedge funds and other vehicles, only provided that those investors are worth $1 million. This is an exemption that preexisted Dodd-Frank but was made even more difficult, and it preserves investments for people only if in the top essentially 1%, as estimated by the SEC. I would re-examine that. I would re-examine the idea generally of using wealth as a proxy for sophistication. I think that we could all name a movie star that might be wealthy but might not necessarily be a sophisticated financial investor. I would consider also maybe a financial literacy test to let investors access these opportunities, but I would certainly point out that severe inconsistency in the Obama administration's rhetoric on this issue.
And now we're opening up a whole new ball of wax. But Mr. Bullard,
I'll only respond very briefly to recommend to Professor Verrett a close reading of the Crowdfunding Act. It allows access to precisely those low-income investors, and I think it has a lot of good aspects to it. And I'd be interested to know what he thinks about that as at least the beginning of trying to break down that barrier.
Well, the Crowdfunding Act, as useful as it is, doesn't deal with this issue of investments. Crowdfunding is not permitted for hedge funds and private equity funds. This is a different animal altogether.
But hopefully what this will exhibit with the crowdfunding legislation we're able to get passed, even with the flawed portions that the Senate added to the legislation that we wrote here in the House, and I'll repeat that again, the flawed elements the Senate added, as the Senate is apt to do, I think this will be a useful market to see if you have average everyday investors are able to function in a free marketplace of exchange and buy equity and be a part of the equity side of businesses in a larger mass sort of way with a light touch level of regulation. I think this could show the Securities Exchange Commission how many of their existing preconceived notions about investors are simply wrong. Right? So, we've got a couple generations of securities laws in this country that assume, based on wealth, that you are sophisticated, which is absolutely absurd, especially in the Internet age, when information is more diffuse, more available for individuals than in the history of mankind, truly, in the history of mankind. And so with that, I certainly appreciate your testimony. I appreciate the panel's willingness to engage in these ideas. And Mr. Collins, I certainly appreciate your service in government, and thank you so much for the hard work you put in, especially with this final report that has culminated in this hearing today. Thank you. And thank you for the rest of the panel. Very interesting ideas and very serious thought you've given to your testimony and the words you've offered today. Today was really about the cost-benefit analysis of the SEC and the larger ramifications it has on the marketplace, and the importance of a cost-benefit analysis when you're in the rulemaking process, whether it's mandated by Congress in law that a regulator write rules, or the regulator takes it upon itself to write new rules. The cost-benefit analysis has to be an essential ingredient before a rule is put into place. Even the best of rules do have a cost and a benefit that need to be analyzed and weighed. So thank you for being here today, and thank you for your testimony. And this hearing is now adjourned.